Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets.
Hi, welcome to Securing Your Brand with Holly McFall and Melissa Jetta from Secure Mark Legal. I'm Matt Sky. Join us as we delve into trademarks, copyrights, and intellectual property. Holly, Melissa, thanks for joining us.
Hello. Thanks for having us.
So let's jump right in. What constitutes copyright infringement, and what are the key elements needed to prove it?
All right. So pretty simply, copyright infringement is using something that is copyrighted by someone else. There's no requirement of intent to do anything or knowledge that somebody else already owns that thing that you're using. Unfortunately, it is just a strict liability sort of thing. If you use it, it doesn't belong to you, you could be liable.
It is really that don't right click and paste it. Don't use art, logo, image that doesn't belong to you that you don't have a license for. You have to make sure that you have the proper license or the proper use or the right to use that image, that photograph, whatever it may be, that creative work, and use it for your own good.
Now, who can be held responsible for copyright infringement, and under what circumstances are multiple parties liable?
So generally, it would be the person that did the infringing. You know, if it's that simple, if somebody steals a photograph and posts it on their Facebook page, obviously it's that person that stole that photo. When it comes to things that marketing companies might do, which is, a pretty common scenario. If you hire a marketing company to design your website, for example, and they use images that they shouldn't be using, it's the owner of that website, it's you that's liable for it, not the marketing company that you hired. So that makes it very important to keep track of what they're doing, make sure that the marketing company understands copyright law, understands, what those parameters are that they have to follow, which, they should know, being a professional company, but it's on you to keep track of that. So having an image log is important. An image log would be, a log that you require them to keep every time they use an image for your website or your social media. Track where that image came from, any licenses that they were relying upon. If they used a proper license or paid a fee for it, keep records of that in case someone comes by, years down the line and says you didn't have a right to use this, or your marketing company didn't have a right to, that marketing company may be long gone by then. You're not using them anymore. Maybe they even went out of business, but you'll have that proof that you need to defend yourself against copyright allegations.
So when you're looking at the different types of copyright infringements, how do you know which type it is, if it's direct, contributory, or vicarious?
It really doesn't matter because there's no intent standard here. It doesn't matter if you intended to do it, you didn't intend to do it. You did. It's strict liability. So however you, like Holly said, however you're getting your images on your website, on your social media, you're going ahead or even posting someone else's product, you are infringing on their copyright, and you need to know how that image got there, whether it was a Creative Commons use, whether it was a license and you purchased right to use that photograph, and what parameters you had that license for how long, for what purpose, those kinds of things, what website that came from or where that image came from. You want to make sure that you understand all of that. So that way you know that later on, if you do get a cease and desist letter, wait, this is where I got it. I have right to use this. It was a free public use. However, where that image came from, you want to understand where it was or where it came from.
So what should an individual or organization do when they do receive a cease and desist letter for copyright infringement?
You want to go make sure and see where that image was used. So you got a cease and desist letter that says you used my image, you used my photograph, and you didn't have authorization to do so, and we're charging you, X number of dollars because of that infringement. You want to first go backwards, show where that image was. Where do I have that image? Where is it on my website? Now I know where it is. Do I have rights to use that photograph? If I didn't have rights to use that photograph or that image, I want to then take it down. I want to make sure I immediately rectify the situation. Doesn't mean you're not liable, but you want to make sure that you've at least stopped infringing and going forward with the infringement. Then you want to go and do some research yourself. You want to go ahead and see how is that image actually copyrighted? Is that image available on a free use site? Is that image available for lease? Is that image available under the Creative Commons? What are the rights to use that image, that photograph? And then go from there. You're going to want to consult an attorney and say, this is what I have, this is what I received. And they're going to do that same kind of research. They're going to take a look and see how What is the value of that? Go through that process. If you could license, if you could get that photograph in another way, and it's not going to be costly. It's not costly to get most images. Maybe you settled that lawsuit, you settled that infringement or cease and desist letter. So that way you're not, going through full litigation stage.
That research stage is not only to determine whether or not you agree that you infringed, but also to determine how much you should be paying. If they're demanding $10,000 and you can buy that photo for $10, maybe you just go ahead and offer $10 and, instead of hiring an attorney, if you're on that very low end.
Yeah, I was going to ask, how often is it an easy solution in terms of paying 10 versus an enormous settlement?
It happens more often than you would think. A lot of these copyright trolls, we call them, these firms that do this, for a living, that's what they do, especially with AI now. They're searching for all of these possible infringements. Sometimes they just send out a whole bunch of letters, not necessarily knowing whether or not they have a good case, just kind of throw it at the wall and see what sticks. So you may be one of those, lucky ones, I could say, receiving this letter, but improperly, and you say, I really honestly did nothing wrong. You got the wrong person, or, this is silly. And sometimes they do, when they double check their work, they might say, okay, you're right.
So how is the value of a copyright infringement claim determined then? And what are those factors that goes into that?
Basically the factors that Melissa just went through, figuring out the value of that work that you infringed. Sometimes it may come down to if the other party lost actual revenue because of your alleged infringement. Let's say we're the ones that stole or improperly used a photograph and it was a valuable piece of artwork that they were actually selling for thousands of dollars and we stole it, so therefore they lost revenue. They may try to prove damages in that way. There's another topic that we could touch on with statutory damages. When we're talking about copyright registration, if you're the owner of this copyrighted work, a big advantage of registering a copyright with the U.S. Copyright Office is statutory damages, which means that if you are the one accusing somebody else of infringement and you file a lawsuit in federal court, even if you don't have any damages, or even if you just decide that it's too expensive to try to prove actual damages, you can rely on these statutory damages, which would be a set amount determined by the judge per infringement. It can range anywhere from $500 to $30,000 per infringement, just solely based upon the fact that they infringed on your copyright registration. So even if you had no damages at all, this photograph we're talking about, you're just a photographer in this scenario, posting photographs on your page, your Facebook page, to promote your photography business. You're not selling these photographs, but somebody stole the photograph. You can't say, I lost $100 from that sale, because you were never selling those photographs to begin with. But if you have statutory damage rights, and you can ask the judge, say, Judge, we believe we're entitled to $2,000 statutory damages per infringement, just based on the fact that we have a copyright registration. That can be a huge advantage in a lawsuit like that.
And can you tell us the concept of fair use and how that might be used as a defense?
Fair use is not a license. Fair use is not an agreement for you to allow you to use that image. Fair use is a defense for something you've already done. You've used this image and you're saying that I have fair use over this image because it's either in a comedy, it's educational, it was a parody. It wasn't that I'm infringing on your copyright. I have now changed that and I have fair use to change that image or change and use that image in regards to how I'm putting it forth in the world. It's now either new and creative, or it was fair use in regards to I have now changed it. I've used it in a parody, a comedy, education, and it is not infringing on your copyright. So it's a defense, not actually a license to use. You can't say, oh, I can use this image, I have fair use. That's not it. You got to go back and use it as a defense after someone has charged you with copyright infringement.
And that can be an expensive endeavor, of course, being in court. An issue like this, if it comes down to it, to an actual trial, that would be, you have the subjectivity of either the jury or the judge. You don't know which way they're going to go. But, trials are expensive. They require a lot of time and money and preparation and arguing those issues, so it's a huge risk. Fair use, while it can be a useful defense in the right circumstances, it's certainly not one that we advise relying upon without some really good legal analysis and advice.
So fair use is only fairly useful.
Exactly.
What role do licensing agreements play in preventing copyright infringement? And what should someone do to ensure that they're effective?
You want to make sure that you actually can use that image. It's either in the public domain, it's under the Creative Commons, and you're following the rules in regards to that, or you've purchased a license to use that image. Your license, your agreement to use that image depends upon the scope. How long can I use it for? What can I use it for? Can I use it only on my website? Can I use it only in my social media? I have now purchased the rights to use that image. So you're the owner of the copyright, the creative use of that copyright is being allowed by the owner.
So it's kind of on the opposite end of the spectrum from fair use, right? Fair use is very little guarantee of what your rights are, versus a license agreement is in black and white, all of the details that you can possibly think of, you agree to it up front. And as long as you comply with the terms of that license agreement, you should be pretty safe, or you've got a good leg to stand on if you're brought into court for some reason for violating that license agreement.
Are there often misunderstandings in license agreements? I'm sure there's always so much legalese when these are drafted.
With every contract, you can always have an argument as to what was the scope of that contract, what was the purpose, what was the use of that contract or that item. So yeah, you could, if someone has gone beyond the scope, that you've given them a license to use your work, you've given them the right to have that agreement, they could, make an argument that you've gone beyond the scope, you've used it for longer than you were supposed to, it was only supposed to be licensed for a set purpose or a set time. You could have an argument in that regards to it. It's important to make sure that when you're using or you're hiring someone to work for hire and they're creating an image for you and you're creating your license agreement with them and how that's going to work, you want to make sure that you have put in all of your parameters, where it ends, where it starts, what is going to be used for, and you want to make sure that you've covered everything that you need that photograph for, or that you're allowing someone else to use your image for.
Let's jump into something that I think is probably one of the most relevant topics today, AI and its impact on copyright infringement. What are your thoughts?
AI is going to play a large role. It already has started to play a large role, both in not only copyrights, trademarks, all types of intellectual property and patents. We've talked about the fact that trademarks are in relation to your business. In that regard, copyrights are creative work. They require an authorship. The courts have come down and said that the authorship has a human element. It's a human authorship that has created this work. They've put it into tangible form. There's a case out there. They call it the Creative Machine case, Thalmor versus Perlmutter, in regards to what is authorship, who owns and does that copyright. There was 100% created work by AI. Yes, a person put it into that computer program and wrote the computer program in which to be able to have it, but the computer designed the artwork. And that is not human authorship. You cannot register a work for copyright that is 100% created by AI. The copyright application before the Library of Congress asks you, how much of this work is done by a human? How much is done by a computer? And they're asking you for a percentage determination. This case has determined that 100% cannot be copyrighted, but where that percentage lies and, kind of on that scope, we have to wait and see where it's going to go. I can also see where AI is going to start infringing on maybe patents, and machines are going to start making inventions. And is that, do patents require human interaction? Is that necessary? We see it in trademark when they're go ahead and you're creating a work within a product or a software that is done by AI. Can you then trademark that image? Is that logo that was designed by AI trademarkable? And what is the percentage of that was created by AI and created by human? And how was that designed? We're all going to, case law that's going to happen in the future that we're going to see as it changes.
Melissa, just one more question on AI. Do you think we'll come to a consensus on what percentage has to be human generated versus designed by the machine? Like, what is that? Is it 50%, 90%? Like, how much of a human contribution separate from the actual AI has to be there, do you think?
There's no current case law on that right now that's saying it has to be this or it has to be that. With the Library of Congress, with applications, we are seeing that they are erring on the side of more caution. They want more human interaction, more human creativity to it. Copyright is protecting our ability to design things. Art is more than just art. It is our society. It is reflecting of what is going on around us right now. And, as AI changes and as we advance in technology, I'm sure that's going to kind of mold and change too. But currently right now, Library of Congress, more human creation, less AI creation. But the percentage determination has not been determined.
So we've covered a lot of territory. Can you discuss a notable copyright infringement case and the legal principles it highlighted?
One that comes to mind, we actually were talking about fair use, so let's stick on that. It's Jack Daniels versus, I think it's Bad Spaniels. It was the dog toy case where there was a parody. They had the dog toy was arguably the same shape, the same look of the Jack Daniels bottle. And it was a dog toy, though, and they called it Bad Spaniels. And even the logo that was on the bottle, the dog toy bottle, looked exactly like the logo for the Jack Daniels bottle, except it was, barkable instead of the alcohol content or something along those lines. And the company for Bad Spaniels, Bad Spaniels, I believe is the name of the case. They argued that it was fair use, that it was a parody, that it wasn't an exact infringement. And no, the courts came back and said, no, that wasn't a parody. It wasn't fair use. And so that fair use argument is really subjective, and it really is a defense. And you're using it after you've infringed, and to have legal, opinion before you're going to infringe on somebody or change something. You want to make sure that you understand what that is and, what the consequences of that infringement were.
Is it harder when it's your entire brand versus one product you sell?
It is. Copyrights don't have to relate to a business, but it is definitely more difficult when you're looking at an entire company or you're looking at an entire line of artwork and those kinds of things. There's no intent to infringe. It's not a requirement in copyrights. Your intentions, your purpose are not an element that they're considering, the courts are considering, until you use the defense of fair use. And then that's when you're asking them to look at my intent, what I was doing with that image.
How much does that intent play a factor? Let's say Bad Spaniels genuinely didn't even know about Jack Daniels. I mean, obviously they did, but if they didn't.
It wasn't an argument that they made. It wasn't something that the courts determined. They determined that it wasn't fair use, and that was it.
So, Melissa, Holly, if someone had one key takeaway from this episode, what would that be?
I think there's two things here. One is to make sure you have the right to use that image. That if you're going to use someone else's work, you want to make sure that you actually have the right to use someone else's work. That's their creative product. That's their copyright registration. Once it is registered, they are the presumed owner of that copyright. The other takeaway here, besides making sure that you have ownership or you have right to use it, is your intent doesn't matter. If you infringe on someone else's creative work and it's a registered copyright, then you're infringing on it. If you intended to do it or not, if it was done by you or your marketing company or someone else, if you were the owner of that page, that social media, that's really where it comes back to for businesses. If you were the owner of that page or business, you're going to be liable on it because your intent doesn't matter.
I would probably just say that ownership or that responsibility of the infringement being on you, that's really big. And it's just something that a lot of businesses don't consider. They think that if an image is on the World Wide Web, it's there for anyone to use. That's a very common misconception that can be a very costly one.
No, it's great to keep all of that in mind, and it sounds like there's a lot of power to prevention. All right, everybody. Well, thank you so much for tuning into Secure Mark Legal. For more information and to connect with Holly and Melissa, be sure to visit securemarklegal.com and find them on social media. Melissa, Holly, thanks so much for joining us.
All right. Thank you.
Thank
you. It's been a pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.